Welcome to the ExitEngine Podcast, where we help founders, owners, and entrepreneurs turn their businesses into assets buyers fight for. If you're looking to grow smarter, reduce risk, and ultimately exit stronger, this is the show for you. I'm your host, Joe Stapleton, and with me as always is my partner in value and saleability, Mr. John Kniff. Good morning, John.
Good morning, Joe.
John, today we're going to talk about property, but not the kind of property that you're used to. We're going to talk about not real estate. We're going to talk about the intellectual kind, right? IP, patents, all this actual property that a company or a founder can own that's going to obviously make a major contribution to the value of the overall business, right?
It's so important because obviously, property and real estate is things you can see and you can touch, right? Intangible property and intellectual property is key to so many businesses, especially these days. It's just a critical asset that not that it gets forgotten, but I think people it's sort of underthought of, let's put it that way.
And there are things around the thing about this today, because we're going to talk to somebody who is an expert in intellectual property, and we're going to talk about specifically the ways in which where you can handle and treat that property so that you can maximize its value. But first, John, let's talk about the new ExitEngine ecosystem. It's everything and everyone you'll need to plan and execute a successful exit on your own terms and timeline.
ExitEngine helps founders grow smarter and exit stronger by providing diagnostics, roadmaps, coaching, community, and advisory support that reduce risk, increase value, and make their businesses buyer ready. It's the first exit planning ecosystem in the world, and you can start for free right now. Just go to www.myexitengine.com.
So today's guest is Brenna Legaard, and Brenna, thank you so much for being here on the ExitEngine Podcast.
Thank you so much for having me. I have so much respect for what you guys are doing, and I'm so happy to be part of it.
Oh, thank you so much. That's really, really kind of you to say, because what we are all aligned. And when we first spoke, the thing that really stuck out to me was how there is so much around IP that people don't know, right? And,
yes.
And I think it's similar to the exit planning space in general, right? We are constantly kind of facing, the challenge of education around this stuff. And I think IP is really the same way for you, right?
Mm-hmm. Yeah, it very much is. I talk to people who envision exits a lot, and people have they have a very narrow idea of who an innovator could be, what an innovative company looks like, what their innovations are or aren't, and what they really need help with is understanding how to frame what they have. How to best protect what they have, but mostly, honestly, how to articulate it to a potential buyer or business partner or anybody else, especially if they fall outside that kind of relatively narrow framing of what an innovator should look like.
Right. Well, let's step back for a second and just talk a little bit about what is intellectual property, right? So what are there different categories or different kinds of intellectual property and that kind of stuff? Can you give us kind of like a little bit of an overview of what IP really is and what are the elements?
Yeah, absolutely. So you start from the premise that everything in the world is completely fair game to copy. Copy all you want. It's not a crime. Go ahead, copy whatever the hell you want, right? Unless that subject matter falls within a few defined categories, and that's intellectual property, right? So the first one is copyright. Copyright protects creative expression. It protects creative expression. So the tangible expression of an idea, and it was originally kind of envisioned for artwork. It often protects software and other sort of more industrial or technical things. It doesn't protect the underlying ideas. It only protects their tangible expression. The second category is trademarks.
Mm-hmm.
So trademarks are any kind of word or phrase or anything else that's used to identify source to a customer, right? So trademark has kind of a dual, public interest, public protection, and brand owner protection, right? So use trademark law to make sure that the brand equity you've built, right, all the positive those positive associations with you, right? You make sure that when, somebody's looking at a podcast and it's called ExitEngine, it's you guys, not
Right.
someone else offering an inferior product, right? So it protects you as the builders of this brand, right? And then it protects your customers as people who are looking for you.
Got it.
And then you've got trade secrets, right? And so trade secrets are, it's commercially valuable information, economically valuable information that you manage to keep secret. It's pretty straightforward, right? And then patents is the last one.
That the trade secrets, like the formula for Coca-Cola, right?
Formula for Coca-Cola. Okay. But even beyond, we can talk about this more, right? But I'd argue for a pretty expansive view of trade secrets. And if there's one thing that companies out there have and don't recognize, it's absolutely trade secrets.
Interesting.
Cool. Okay.
Yeah. It's a, I mean, when I kind of dig into a company, right? Like, usually there's valuable copyrights that they haven't really, protected or considered or thought about. And so we do something with that. And then we take a look at their branding strategy and how well it aligns with trademark law. And then we do a lot usually with trade secrets because
Cool.
there's usually a lot of value there that they don't even recognize. And then the patents are the last thing.
And the patents are specifically around the design, right? The technical development of something that is, and it has to be kind of profoundly new, right? Somehow.
Yeah. So patents protect inventions, right? And so invention can be a new way of doing something technical. It could be like a composition of matter, right? So there's a lot of overlap usually between trade secrets and patents, right? So you could probably get a patent at one point. You could have gotten a patent potentially on the formula for Coke, right? Yeah. But also, the software is frequently patented, and then any kind of mechanical device, is potentially patentable subject matter. But the thing about patents is that you have a window to file. And if you miss your window, you're done.
Gotcha.
And then you've got to go through the process, right? Like you can have a trade secret by recognizing and protecting your trade secret, but to have a patent, you have to apply for a patent and you have to be granted a patent. And like the requirements are something kind of fit within those buckets of patentable subject matter, right? Like it can't be an abstract idea or a natural phenomenon, right? It's got to be something you made or invented, right? And it's got to be new and it's got to be non-obvious and it's got to be useful.
Interesting. It's got to be useful.
It's got to be useful.
And the patent, interesting between the patents, and we can get into this too, but I think one of the reasons why Coca-Cola didn't patent its formula is because wouldn't it have to be released to the public at some point?
Yep.
Okay.
Immediately. I mean, within 18 months, right? So the quintessential bargain at the heart of the patent system is you tell me your thing and I give you a limited period of exclusivity. Right. So the first patent statute or the first patent law was promulgated by the city-state of Vienna in 1474. And so at that point, Vienna's primary industry was stained glass, right? So exporting amazing, beautiful stained glass. And they had all these the glass masters had these formulas for amazing colors of stained glass. Right. And they're probably crazy toxic, right? You can only imagine. But but they lived in people's heads.
And stuff and lead and
yeah. So when something happened that had, right, it left the city-state of Vienna or got hit by a carriage or whatever, that knowledge was gone. And so Vienna identified this as a problem. And so they said, all right, like you inventors of novel contrivances, if you come into the state judicial office and you tell me tell us what it is, and they write it down, and then they get a 10-year period of exclusivity. And so, the Vienna did this in order to create a catalog of this intellectual property, right? And the glass artists took advantage of it because they wanted the exclusivity. And that is the essential bargain. In the US and now all over the world. Like I would say the patent system is one of our most successful cultural exports, right? In the United States. Like everybody's got a patent system that's, a lot like the one that was framed in the Constitution and by the founders in the first patent statutes in this country. And the essential bargain is you disclose your thing and you get a limited period of exclusivity. But as you point out, John, trade secrets last forever as long as you manage to keep them secret.
Yeah, and the interesting thing about the bargain that you talked about, right? It's there requires a lot more in society and in business culture that would make that work, right? So in other words, you're going to use the patent system if you're confident that the government or the authority that's enforcing that will actually enforce the patent law. Because the last thing you want to do is I disclose my Coca-Cola formula, and then you don't have a government entity or an authority to enforce your exclusivity period. Again, that example, because it's a trade secret, but what I'm saying is a patent, like if no one enforces that patent and you're and honors that exclusivity, then what's the point?
Yeah, that's exactly right. Yeah, that's exactly right. And this can get a little bit, you know, I don't know if you guys want to run with this, but I'll say it and you can decide, right?
Yeah.
So you know, I started practicing in 2001, right? And in the kind of mid-aughts, right, 2005 to 2010, you had a lot of patents that covered, you know, standard business methods only done with computers,
Right.
or standard business methods only done with the internet, right?
Deliver flowers over the web, something like that.
Yeah, things like that. And people patented those, like the famous eBay one-click, you know, patent, right? Or I think it was Amazon. Anyway,
Amazon,
the
yeah.
point
Amazon
is,
shop,
yeah,
one-click
like a lot of business methods, like honestly, business methods only done with a computer. And the patent office was underfunded at that point, and it didn't do a great job through the late 90s of, you know, examining those patents. So you had a lot of like kind of patents out there. And then the Eastern District of Texas promulgated local patent rules. And I think that was actually a really important contribution to the legal system. But what it did was create a perception of a very favorable patent forum. And so you had a lot of patent suits that people didn't regard as super legitimate. And then you also have these gigantic tech companies like Google, right, and Microsoft and the others, right, with, you know, and they don't need they have a lot of patents, but they don't need them, right? Like they succeed via sheer market dominance,
Right.
you know. And so you've got this sort of perception, and then in some ways reality, but lots of perception of patent troll. And you have, you know, the tech industry feeling like maybe they shouldn't be enforcing patents. Maybe patents aren't for suing people. Maybe that's not a moral thing to do, right? Which is kind of crazy because,
Right. Well,
again,
and the open source, hence the open
the
source.
open source people. Yeah. There's a period of time when I get on an airplane and like, if I tell somebody in the airport that I'm a patent lawyer, I got lectured about open source. Like it was a little crazy, right?
Yeah, I bet. Yeah.
Yeah, no, it was a big thing. Absolutely. Yeah.
I sat
Linux
next to a
and
dude one time who
Linux
sold title insurance, you know, and
Right.
he asked me what I did. And I told him I'm a patent lawyer. He's like, isn't the patent system messed up? And I'm like, dude, you sell title insurance. Like, come on, right?
Talk about messed up. Right.
I mean, what do
We're
you
not going to
do?
get into title insurance. I know way too much about title insurance. We're not going to go there on this stuff.
He explained it, and it was fascinating. But anyway, so the problem is, again, like if you're a small company, you know, I mean, everything that you create is up for grabs, but for the IP system. And so if you're Google, you do not need it. But if you're not Google, you need it.
Well,
right?
Let's stick on that for a second. So like when you're counseling, like someone comes to you, right? You get someone throws something over the transom and they come to your firm, they get in touch with you, you have a call with them at 10:30, right? And what is your guidance for someone who said, I have this novel way of doing XYZ using software? How do you sort of what's the positioning, or what are the questions you ask that entrepreneur about that idea, software, that type of thing?
Okay, so it's software.
Yeah.
So for software, and don't generalize this beyond software, right? But for software, we talk about like who's the audience? Like, is this a B2B play, or is this consumer?
Yeah.
You know, like how novel is the space? How abstract is the space? Like, is this basically a business method, or is there a more kind of technical output? So by way of illustration, right? Like I'm in Portland, Oregon, the home of Nike. And the city is, I don't want to say awash with, but like there are a lot of kind of advertising method tech companies,
Sure.
Right? Like novel and sometimes really genius ways of scraping, analyzing, crunching data in order to enable other companies to maximize their prices or something like that. The output is behavior, right? And so that that's dicey subject matter for patenting, right? Like you can kind of get there's a rule that you can't patent an abstract idea. And
Right.
so something that causes a human behavior as its only output, like, and then the other thing is the patent system is long and arduous and slow and expensive. Right. So if you're not really sure that the output, I don't know if I can get you a patent or not, like we can throw together a provisional, and often it's a good idea for fundraising because often the tech fundraising community expects patents even on stuff that, isn't necessarily great.
They like
subject matter
to
for
reduce
it.
the risk by having the patent, so whatever. So they want to make sure that everything they can patent is patented so that they're protected from an investment standpoint.
Yeah. But if you're the company and you've got to choose between hiring a sales guy and drafting a patent, like sales guy,
Right.
right? If you're in that space.
Totally. No, absolutely. And this brings up again, this is actually a great point, because what we see all the time in the exit planning thing, right, is that you are taking the short-term win over the potential long-term, effect of what you're doing, right? And it's easy for it happens to all of us, right? All business owners, all founders, anybody who's running any kind of organization at some point is looking and constantly balancing this kind of short-term effort versus this long-term gain and that kind of stuff. And how do you look at this? And of course, we're talking about exit planning, which might be the ultimate long-term play, right?
Mm-hmm.
John always talks about how it's like, what we're selling here is diet and exercise, which is difficult, right? It's like, yeah, I get it. And if I can stick to that, right? But it is, but I think the patent game is the same, is similar, right? It's like, it's a matter of, you don't want to spend, you have the choice of, I can get a sales guy right now and get this top line revenue up, right? And hopefully then my profitability as a result or whatever, or I can spend, thousands of dollars on a patent getting this together that will be, and the question is balancing that value, right? Because what is the long-term value of having that patent to my organization overall? And one more sales guy and getting revenue up right now, but again, difficult call, because it might be that you are in a situation where I need that top line revenue right now.
Yeah. And the thing about it is, right, like it's, and that's, again, like we're talking about a fairly data oriented, or like a consumer behavior data oriented software application, right? Where, again, like that's difficult terrain. It's not impossible, but it's a little difficult. But if you're in deep tech, you have to have patents. If you're in any kind of regulated industry, you have to have patents. And again, like anything in the world, like it's up for grabs, copying wise, unless it's a form of intellectual property. And it's almost always easier to copy than invent. And in certain industries, it's orders of magnitude easier to copy than invent.
Hey, I'm Joe Stapleton.
And I'm John Kniff.
John, most founders put everything they have into building their businesses. Years of sweat, sacrifice, and problem solving. But when it comes time to exit, many are shocked to learn that what buyers value isn't what they thought.
Here's the truth. Buyers don't pay for potential. They pay for proof. Proof that your business can grow without you. Proof that your financials are clean. Proof that your processes are clear and repeatable.
If you wait until a buyer shows up to think about these things, you're almost guaranteed to leave money and control on the table. ExitEngine was built to change that.
ExitEngine is the first readiness platform that helps founders design their ideal exit step by step, combining education, coaching, and support, and access to an elite network of business specialists and capital. ExitEngine empowers you to build a valuable, transferable business and exit on your own terms.
It's not about selling tomorrow, John. It's about making sure that when you're ready, your business is worth what it deserves to be.
Don't let your life's work get discounted. Control your business destiny today. Start preparing now while you still have time to engineer the exit you want. Visit myexitengine.com to learn more. And Brenna, just can you go into like why you have to have patents? Can you just expand upon that? Why do companies have to have patents? What's the benefit?
Okay, so in any kind of regulated space, right? Like, pharma, med device, and I see a lot of med device, right? Like you've got an FDA clearance process ahead of you, right? And that's expensive and difficult. But then once you've proven that a certain technology, works is safe and effective, right? Like it's, like that finding inures to the benefit of your competitors as well, right? So if you hope to recoup your investment in all of that R&D and that clearance process, like you have to be able to fight off your competitors, or as soon as you poke your little head up into the market, they're going to eat you alive. And nobody in their right mind would invest in you.
Yeah. So I didn't mean to. Sorry.
Yeah. Yeah. And then, so deep tech, so that's a regulated industry, right? Yep. Deep tech, which is a, sort of more fundamental science, right? Like that just takes a really long time to get to market. And there's a lot of times, the hard part with deep tech is proving that it works, and proving that it works like well. And so once you've proven that it works and proven that it works well, again, like you've spent a lot of time and effort and money to get there. And once you've done that, you're pretty easy to copy, especially by larger companies, right? If you're a smaller entity, right, you're trying to prove up something, like the minute you prove it, it's super easy for a multinational to knock you off unless you have a patent. So it's one of those things where like, if you've got to really invest heavily in the creation and you don't have a period of exclusivity, then, why wouldn't someone just copy you if it's such a great idea?
Right.
If it's software and you're flipping it out to the public, speed and branding is where you're going to live or die.
Yeah.
Right. But if you're doing science, that's hard. Software's hard too, but science is hard.
But the landscape in science and biotech and the pharma industry and the whole thing is such that there's so much time that goes by where this stuff, if it was out there, could be reverse engineered relatively quickly in the whole thing. And someone could potentially beat you to market if they had the right resources and stuff. And I think that's obviously what the whole discussion around China has been for so long too, right? Which is that their whole, there's depending on who you believe, there's potentially that they've got a purposeful method out there, right, of being of reverse engineering everything they possibly can to redo it and to be able to do it cheaper and faster, whatever, if not at a higher quality necessarily, but maybe at a faster production pace and things like that, right? So but that's exactly there are things like that, like you said, and I love the phrase because I think this is an important thing for all of us to know, really, is just to say that the notion that assume everything will be copied, right?
Yeah.
So
everything worth copying. The critical bit of information that people need to copy your thing is not your thing. They can pretty much figure that out. It's knowing that it's worth it economically.
Right. That's it. Right. So they got to know whether or not from an economic standpoint, does it make sense for me to do this? And should I be building it or should I be doing my own thing? And then even the process of like go back to the Coke example, right? Where Pepsi one day comes along. I don't know how far after Coke it was, but it was probably a good distance just because it was but there was something about the way Coke did it that made Pepsi say, hey, we could do this too. And maybe we could do this better.
Yeah. Yeah. And that's something was, wow, look at all those people drinking that stuff.
Yeah. Right. It's like, well, there's plenty of market share here. We could take this away if we made it a little bit sweeter or whatever.
The random story about Pepsi is they actually got the Coke formula and let Coke know. Like back in the day, like one of the employees of Coke tried to sell the formula to Pepsi. Yeah, it's a crazy story. We're not going to do
industrial espionage there. Yeah.
But those are real things, right? That corporate espionage. The way of undoing the stuff, and again, maybe today it feels like everything's more open in general. There are more people building in public, there are more people out there kind of sharing ideas. And like you said, so much of it is software related, right? It makes it so much of it makes it difficult to actually patent.
Yeah. In margins, the worldwide are slim, right? And so the other kind of, so when I say like the piece of information that leads to copying is not usually how the thing works. It's that it makes money,
Right.
And but like there's there's a lot of value in the kind of little edge implementations that create efficiencies, right? That's when I say that companies have trade secrets and don't know it. It's those little edge efficiencies. It's the little things that that usually are the difference between something that's profitable and something that isn't.
Yeah. Right.
But it's kind of back to that information, right? Like those things are a little more difficult to copy because they're often manufacturing processes that aren't really evident from the thing. But with that caveat, anything can be copied now, like anything.
I think of like, and this may be a bad example, but like cloud computing, right? Like everyone's doing cloud computing now, but like I'm assuming that that Microsoft and Amazon and other cloud providers. Was Oracle? Yeah,
Oracle was the one. They were the ones.
Yeah. Like they're doing it differently in the sense of whatever. And I'm not a technician, but like storing the materials and recalling the stuff. Like, is that something, Brenna, that could be patented by Google to say the way that not the cloud computing we can't patent, but the way that we recall or the way we store the information on our servers is patentable?
Yep, absolutely. Okay. Yeah, absolutely. I mean, that kind of like technical subject matter, when I say deep tech, like deep tech is on computers too, right? Like, improved ways in which how they process data, how they exchange data, how they send data, cybersecurity. There's a lot of patents in cybersecurity, things, all of that is fair game. Yeah.
And right now, I mean, in particular, obviously the cybersecurity space is a big one. AI obviously is got to be huge, right? I mean, there's so much of that going on right now. Have you been following? I mean, is there any insight you can give us in terms of like what's happening from an IP standpoint in the AI space? You see all these things like, again, we all use ChatGPT now, the way that we use Google, probably it's become that quickly kind of ingrained in what everybody's doing. That's been given away practically, right? Like, the tech used to consumers, but what's the IP behind that like?
So Anthropic, OpenAI are absolutely patenting innovations.
Right.
They're absolutely building patent portfolios. And I mean they're sort of AI assisted ways of doing things. That's subject matter that is absolutely being patented. And the legal system is very much struggling with, like how much AI is too much AI for there to be human inventorship, like how much AI is too much AI for there to be, copyright eligibility, things like that. And those questions are kind of in the process of being, worked through.
Right.
The new patent commissioner has a strong opinion about, the need for there to be eligible patent subject matter in AI creations. He's not a judge, so we'll see where that goes. But I think it's important. If you're, if the idea is that patents should serve the important technologists, the important technologies, the important innovations in a society, then you got to think about the value of carving out chunks of subject matter. And so I think it's really important to think hard about where the lines are in AI. But that's in the process. I mean, it's in the process of evolving. Like the legal system doesn't have a better idea of what to do with this than anybody else does.
Yeah, because these things have to be protected, right? To your point, like we want. The government wants to foster innovation and wants to foster new businesses, and to the extent that that the guardrails are there and that people know that their inventions will be protected. I mean, again, they must be novel and fit all the criteria. But the wrestling with what is patentable in this AI world, I'm glad I'm not doing that. Let's put it that way.
And it's also I mean, China's huge filer. Chinese entities are huge filers of U.S. patents, and so there are sort of different ideas about what that means and what the law should be and how the law should work. And so not to get deep into the inside baseball aspect of that, like that means that there are Chinese invention disclosures. So for example, China's been trying not to export battery technologies, but it's still filing battery patents.
Interesting.
So that information exchange aspect, continues abreast, right?
Right.
even as trade barriers otherwise create limitations in markets.
When they file those patents, though, are they filing patents? I mean, there is a certainly I'm going to use the word state just as a government thing, right? Or as a place. Like, there is patents, and the whole thing also have a geography to them.
Yes.
Right.
Yeah. Patent rights are national. Yeah.
Okay.
Yeah. So U.S. patent gives you the right to enforce it in the U.S. The Chinese patent gives you the right to enforce it in China. Right. And
so the reason China wants patents in the U.S. is so that they can they can use the U.S. patent law to enforce those patents in the United States. Right.
That is their purpose.
That's a great point, Joe. Because I didn't know that. That's really okay.
Well, we had a client we were talking to that had a lot of this IP, and that was where this came up. So the idea that the state, I'm just using that was the term they used, because I think it's just to show the difference between the state versus the corporation versus the audience or the market, right? So, those filings have to be done in every country in which you want this to be enforced, right? And even though, like you said, it was our system is the one that's been basically exported to just about everywhere else. So the system is probably similar, or at least, whatever, to the US, but you got to file a patent in every country in which you expect to be able to want to be protected. And
that's right.
Right. So, I mean, that's a big deal, because, I mean, think about a corporation, a small business that comes up with this stuff, and again, it depends on where your market is and things like that. But there are people, we talked about the corporate espionage thing, you touched on it just a little bit, but I mean, this is a real thing. And there are people out there that are actually out there looking for these technologies to be able to exploit them in other places, because it is such a process. It is an expense for these people to be able to get this stuff done. So how do you counsel people, and again, I know that you have the same, we talked about this already. Sometimes you got to go to people and say, hey, look, you don't know what you have here, and you've got to protect this stuff. What's your advice around that when it comes to, look, where are you doing business, and how are you making decisions about where to get patents and where to get that protection?
It's where the company is and where its market is, right? And so, as a practical matter, like, you can get a patent in, Azerbaijan, but I don't know anybody who has,
Right. But you want that. Obviously, if you're a U.S. company, you're obviously going to patent that first, because that's where your market is. It's probably the largest market single market you have. There's no question about it. But what is the case when that's not your only market, right? And I mean, what happens if I want to do business in EMEA and Latin America and stuff like that? Right now,
you hit the major markets. I mean, usually the short answer is you hit the major markets, right? Like, I mean, Europe's a tough one, right? Because every European country, right? Unless you do a unitary European patent, which is its own kind of expense, right? So usually you hit the major markets, you hit the UK and Germany and, maybe France, right? And you figure that nobody of any consequence is going to knock you off without hitting one of those jurisdictions. Right.
Got it.
But you don't get damages in the countries that you haven't patented in. Right. So in Latin America, right, you go for Mexico, you go for Brazil. In Europe, you do, China and, and Japan and Korea. I'm seeing definitely more Indian patents.
Sure.
For sure. Yeah.
A lot of software, a lot of technology development.
Yeah, definitely.
Yeah. And a lot of times it comes down to confidence in the judicial system. Right. Because you got to sue them in India,
Right.
So, right.
Well, that's what I was saying earlier, right? It's like, you have to have confidence that if you're going to file it there, you have to have confidence that the system that's going to enforce the patent is there, present and active, right?
Yeah. And so, for the first, especially 10 years of my career, as China became ascendant, right? Like, there was a big question about, is the Chinese judicial system, a reasonable means of recourse, especially to a Western country or company,
Sure.
So, I mean, if you're going to file in China, are you really just giving them a Chinese language dissertation about your tech that you're never going to be able to enforce there?
Right. And that 10 years is going to go by. And by the way, what are they going to do with that technology that you've now basically, or that patent, that information that you've now basically given them?
Yeah.
And they're willing to play a long game, right?
Yeah.
So they'll take, sure, you file any patent you want here, we'll take it, right? And by the way, you invented the system, that we use that gives everybody a 10-year window, and so we'll just wait it out, and then and in the meantime, we can reverse engineer anything we want to reverse engineer. We just can't technically put it out into the marketplace yet. But that day, whatever 3,600 and whatever the 10 years in one day, and bam, this stuff is out there.
Yep. Now, there are mechanisms to kind of put off those foreign filing decisions for a while. We don't need to get into the procedural details, right? But like there's a World Intellectual Property Organization, and there's kind of a structure to file, and then, kind of, put off the nationalization phase, which is a really expensive part, until after you have a better sense of whether this is going to go or not.
Right.
So there are ways of making it a little bit more feasible, but it is a lot of expense, and it's again, decisions you've got to make, well in advance of having all the data that you would like to have to make them.
And Brenna, let me ask you a question. So let's switch gears a little bit, but let's say that you're counseling somebody and they have a patent, right? And they suspect that a company has copied them, or they've borrowed some ideas, they've borrowed the sort of essence of the patent. And there's a couple of different scenarios that you counsel them on. Like, what are the options that a company has in that specific scenario where they've bothered to get a patent, and then, okay, this has happened, or something's happened where they need to make a decision? What are those decision points?
Yeah. So it's funny you mentioned that, actually, because this is why I moved to Invenio. Invenio is like the intellectual property offering in Invenio is very much directed to figuring out what to do with those patent applications or those patent portfolios that people have built, right? Because it is a whole different step, right? There's a lot of decision-making processes and expense and thinking that goes into getting the patent. Then once you have the portfolio, I think people kind of think that others will beat their way to their door and demand a license or something like that, and that isn't really how it works. Like the patent office, your patent portfolio just sort of sits there and absorbs maintenance fees, which could be quite expensive until you figure out what to do with it, right? And so I joined Invenio to do that for companies, to figure out, okay, you've got that portfolio, like what can you be doing with it?
It's a strategic, it's strategic decision.
Yeah. And a lot of it is where does it fit in the technological ecosystem, right? Including, is anybody infringing it? Can anybody use it? Can we put a couple things together and make something that's bigger than that's bigger than the parts, right? Because these are all completely, every situation is different. Like there are some kind of ground rules and certainly things I've learned the last 25 years, right? But everything is different. So I'll start with the portfolio. Often they'll know who their competitors are, right? And they'll know what their competitor technologies basically are. I'll use some patent analytics studies and data to figure out, if there's activity around their sort of technological ecosystem that maybe they don't know about, like the same technology being used for a purpose that isn't really competitive, for example. So it's not necessarily on their radar. Other people who are in their space, who else is trying to solve the same problems, maybe using different technologies, all that kind of thing. Stuff we can tell from kind of patent analytics data, and then we figure out, is there infringement? And are there kind of obvious licensing opportunities or co-development opportunities, or is there somebody out there that they could join forces with that maybe they don't know about, combine technologies and create something that's got even more value. Those are really exciting.
Because that must be really interesting, because you're taking not a problem, but you're turning this company's infringing upon my patent into, hey, here's a licensing opportunity. Here's a business development opportunity to turn it again on the problem versus a challenge issue, right? Or opportunity versus a problem. So it's interesting.
Yeah. No, I got to tell you, being an IP lawyer is the absolute best job ever. It's
cool.
I'm sure you guys have fun too. But really getting in there, understanding, what's special about this, right? And how else does it fit in? But
I love the strategic look that you're taking. And I think that's a real important thing for our audience to know too, right? Which is that, again, this isn't just about, okay, I want a patent. Great. So your patent lawyer is going to come in and give you a bunch of forms. You could do this yourself, right? That's not something, you technically could fill out the darn paperwork, and if you wanted.
Sorry, I've done it, Joe. I try to do it by myself. It is the patent that I'm actually a patent holder, humble brag right there.
Nice.
we're not going to get into that, but the forms and the figures, and I'm using the wrong terminology, and Brenna can correct me, but the format of those patent applications in order to get it processed quickly and to be I'll never get the time back in my life. It was the worst. It's
an
months.
Involved process, and there's a lot of art to it, right? I mean, this is something that I learned from my first mentor, right? Like someone will bring you their invention, but the thing that you should be patenting is not that thing. Usually it's an abstraction of that thing, right? And then which layer of abstraction you run with in your claim strategy. Like there's a lot, and then how is it going to work in other countries? Is it going to US? What is infringement potentially going to look like? There's a lot of, it's a very
the work that you got to do up front, right? To be able to, where you need the expertise really is to say, hey, look, this is patentable. This will get passed. Because what you don't want to do is to take all that work and do all that effort to have it not accepted, right?
That's right.
Because
that's right.
That's the
that's
thing.
Exactly
so the
right.
idea is to know what Brenna's bringing to the table is, again, like I understand that I overspoke when I talked about how filling out the forms yourself, but it was just to bring the point was that no, you need the help. You need people like Brenna to not to fill out the forms necessarily, but to fill out the forms in the right way, right? And with the right tone and the right, the things that they know experience will work. Right.
Yeah. The search before, sorry to interrupt, but the search before was so much of the work that I didn't have anything to do with other than describing what we wanted to patent. And then the attorneys went off and did a search and came back with really pointed, like 5 or 6 things, if I recall, 5 or 6 patents are already out there that were doing the same thing and already had been filed. And it's like, there's no point in patenting this part of the application. You need to file for X, Y, and Z. And the lawyer that worked with us she was awesome. And she pointed us to say, like, forget these 7 things, focus on these 2 or 3. And I think it was 3. And it was like, oh, great. That's way easier in scope. And we can really go into detail. So,
I mean, to give you an example, right? Like, I forgot how to change the names to protect the innocent, right? But I had a company that was making a med device. It was an ultrasound probe, and it was lighter and useful for certain things that it had distinct advantages, right? And so the shape was different, and the angles of the transducers were different, and it was lighter overall. And they've been pursuing this sort of, claim strategy, right, of patenting light probes or slim probes, things like that, right? And they were running into a lot of problems because if you've just got, if you're patenting something it's a question of degree, right? It's the same, it's a thing that already exists. It's just a little lighter. Like that's a hard patent to get because everybody, obviously it's good to make something lighter. So why wouldn't you just make it lighter, right? And but the way that they were running the electrics through, like the way they were configuring the wiring harness, to be perfectly honest, like that was novel, and it was what made everything else possible. Right. And there's nothing else like it. Right. Cool. So when I came in, we switched strategies from an incrementally lighter probe to a wiring harness and a probe that was configured in a certain way. Right. And that led to 3 new funding rounds.
But Brenna, the figuring out of that.
Yeah.
So I'm the inventor of the thing. Right. And I'm looking at the wrong end.
Yeah.
Right.
Yeah.
I'm patent the wrong end. How does that come up? Like, right? I mean, you're brilliant, right? But I mean, you don't have a med device, right? Probe background. What was it that was able for you guys to be able to? What was the mechanism that the lever you guys pulled that it allowed you to understand and make that recommendation?
I mean, yeah. So. I mean, it's the hard thing about it, right, is when clients come in, they're used to talking to customers and funding sources, right? And so they're like, these are the advantages of my thing. These are the advantages of my thing, right? And they're not talking about the technologies that make those advantages possible because everyone's taught them not to when they're talking to customers and funders because no one cares about that stuff, right?
They're talking about benefits with customers and they need to talk about features with you.
Yeah. And I like the sure benefits, whatever, right? Like, and those are important. Obviously, those are important. But what I really want to know about is how they achieve those benefits. And that's the same conversation, whether it's an ultrasound probe or a chunk of software or a novel molecule or whatever it is, right?
Mhm.
Like, how are you doing the thing that everyone wants? Because
And
if
you're
you're not, yeah.
and you're understanding and breaking that down, right? So that when they give you this information, say, here's the whole thing, you guys are looking at the whole thing and going, let's look at this piece and this piece and this piece individually as if they were right. And let's look and go do a search and see if there's things like that out there or whatever, or does it meet the requirements legally, which is really what you're doing, right?
Yeah.
To say, does it meet which of these pieces of this thing meets the legal requirement of being able to be patentable?
Yeah. And it's a communication exercise, right? I mean,
Right.
there are like there are two types of people in the world, right? The people who think that nothing that they create is all that special, and the people who think that everything they create is very special. So,
They all listen to this podcast, by the way.
People present their own challenges, right? And figuring out like, why is this hard? And the thing about the patent system is it's not supposed to reward the ordinary march of technology, right? Like it's supposed to reward the leaps or the swerves or the things that wouldn't exist but for the incentive of a patent. And so what I'm really trying to draw out when I'm doing an inventor interview is, why didn't anybody else come up with this? Like, what problem did you solve? Right. Another example, another med device, there's a doctor who came up with a way of fixing nasal cartilage, right? So what was conventionally this big rhinoplasty procedure, was instead this like little splinting procedure, right? Which was way easier, less expensive, less traumatic, all that, right? And the device looked like an 18th century sewing implement, right? Like it wasn't anything special.
Right.
Like he made the first prototype with like bits of a dental floss container, right? But
That's so
but
cool.
his but like when he really got in there, like his key innovation was realizing that while the cartilage in like your joints won't heal together if it's torn, you have to fix it. Your nasal cartilage is thin and vascular, so if you kind of rough it up and splint it in a new configuration, it will heal in that configuration, right? So like that's the thing. That was his invention. It wasn't the little hooky dealy, right? It was the realization about how nasal cartilage behaves. And so then we have to figure out how to put that, like how to articulate that as a patent claim, and that's why you need a good patent lawyer. Like that's what we do.
Well, yeah, and so building upon that, like the sort of the future, right? What do you see in the future for IP and innovation economy in the innovation economy? Like what is coming down the road? What can we expect, or what should we guard against? What can we guide our client, our listeners about?
I mean, I think that like assertion is going to become a lot more possible, right? So you can now get third-party litigation funding to assert a patent. And if there's enough money in the assertion, if a bunch of other things are true, right? Like you can defray your costs to assert in a way that you couldn't otherwise do it. And I also think I think that's going to be important. I think it's going to be more and more important for people to not just sort of set their patents on a shelf, right? But really think about what they could be doing with them.
Mm-hmm.
I think that I think that foreign competition, particularly technological competition, is only going to accelerate.
Yep.
Okay.
And so getting more strategic about using the IP, like using the creative genius that we have here, protecting it, understanding what it's good for, figuring out what to do with it is going to be all the more important. I mean, the thing honestly that worries me, sort of the most from a person who's in this industry is the massive changes in foreign or in federal funding of science.
I was just gonna go. Yeah, I was gonna ask.
Yeah,
you about
I don't know if you want to go there or not, but no, that's a terrible, terrible thing. I mean, the intellectual property system has, it's a stool with three legs, right? Like one is, rigorous, competent examination by the U.S. Patent Office, and there are reasons to be hopeful there, and also reasons to be, a little discouraged there, because those are federal workers like all the other federal workers, right? And then defensible, like strong patent rights. And the one thing about the Trump administration, I'll definitely say, is that, like there are people who understand that there should be value in a patent, right? And there are people who are ensuring that, especially for smaller entities, that there is value in a patent. And I think a lot of what has happened in the patent office under Trump has been really great. But the other leg is innovation. And a lot of the innovative heavy lifting is done by universities pursuant to government grant.
Mm-hmm.
And that's a big change.
Yeah.
What happens, speaking of that stuff, what happens when a university like that does do this research and itself comes up with the patentable thing, right? Then it becomes what, a licensing situation,
Mm-hmm.
where the university is not going to be able to do anything with it commercially, right? But
Right.
So except for to sell the license to use the technology. Right.
So frequently what happens is if the professors who invented it, like the researchers who invented it, if they want to spin out a company, then they get a license from their universities, they spin out the company, and then they pay royalties back to the universities as they're successful. Universities also license and sell their patents to private industry all the time.
Mm-hmm.
So yeah, universities tend to have large patent portfolios. They tend to be good assets. They're often really innovative, and they're licensed. They're available for private industry to take them and leverage them.
Right. And that's the whole point of why they do this, right? I mean, that's literally why they exist, is to be able to make sure that they're making these innovations, and then those innovations can get rolled out to the people, the corporations and all that stuff that can use them, and and all that stuff. And then obviously it's a major part of the way that they also, I'm sure, the universities themselves fill their coffers and pay for research in the future and stuff like that too, right?
Yeah, and create opportunities for their faculty and their students, right?
Sure,
I mean, I work with universities a fair amount, right? And one of the things that I'm doing is, finding places where, again, like, where does that technology fit in the technological ecosystem, right?
Mm-hmm.
Like, who could take that and run with it, and who wants to work with university, again, students and faculty to kind of form those public-private partnerships that make that happen.
Right. Let's talk a little bit, just bring it back to the kind of smaller business owner, right? Let's just, most of our audience is, somewhere in the, $3 to $15 million range. Okay.
Mm-hmm.
They may be, and again, in various states of their journey too. So we're not necessarily talking about people who are ready to go tomorrow.
Yeah.
But what we are talking about is, again, what are the things from an IP standpoint that you would counsel, in general, businesses, who have any kind of intellectual property, what should they be doing? What should they be looking at? What are the things that they have to be aware of that are going to, again, in terms of the way that this creates value for them, right? Overall, right? It's not about value necessarily today, which it could be, but really about their long-term value.
Mm-hmm. Yeah. So the first place to look at, the first place to look is trademark, right? Like, everybody's got a brand on some level to somebody, right? So are you protecting your brand, which is, it starts from the very basics, right? Like, have you federally registered your trademark? Because you've got to do that, for heaven's sake, right? And then beyond that kind of basic step, like, how are you communicating with your customers about what you're doing? Like, what words are you using to describe your product offerings? How are you telling them that this is something that they need? And when you come up with innovations, how are you describing or talking about those innovations?
Right.
Because, anytime you innovate something, like, you have to talk people into deciding that they want it, right? And you've got to use words and communication language around that. And it's possible to do that in a way that blows your trademark rights, right? You can attach that learning to words that you can't protect, and then you've just opened up a bunch of brand value for your competitors to capture, right? Or you can be smart about it and think about how to attach that learning, that education, to something that you can call a trademark, right? So we talk about, when I go into the company, we talk about that. Like how do people identify you? Why do they identify you? What are they using? Are they using things that are trademarks? Are we treating those as trademarks? Can we start treating those as trademarks? Right? Because you can blow trademark rights by sleeping on them over time, but it's not as stark as it is in the patent realm.
Right.
And then we go into, so if it's technology, if it's innovation, where is that innovation? And again, like I've talked to so many companies over the years. They're like, we're not innovative. We're not a tech company. We're not doing anything, right? But they're usually doing something to be profitable.
To be
Right.
different from their competition, right?
Yeah.
Right.
Yeah.
Something's
There's
different.
something in there that they're doing so that they can make something, that they can make a margin on something, and so we just, and so we figure that out, we figure out, like, what are you doing, that, and often they don't really have a great sense of how what they're doing compares to their competitors beyond what you'd find in, basic sales collateral, right? But they know what they've done to be profitable. Like, they know what they're doing to be efficient enough to be profitable. Like, they know, and so we talk about that, and we recognize that those are trade secrets, right? But and you can call that, like, you can go into an M&A transaction with trade secrets among your assets if you've identified them.
Right.
And
But
then
you have to know what they are, and better be you that identifies them as opposed to the buyer identifying them, because that's going to change the nature of the arrangement. Right.
Yeah, and also you can give away, you could be giving away things, right? If you have a novel way of identifying customers and potential customers from whatever, some sort of formula or scoring or something like that, and you're giving that away, or you're not documenting that for the buyer, then you're not getting appropriate value for it.
That's right. And odds are you're not protecting it like you need to be as well.
Correct. Yeah.
Right. Because once you understand that something's a trade secret, you know that you've got to protect it. And that is a statutory requirement for a trade secret. Like, you have to take reasonable measures to protect it. So we got to talk about that. And then the other thing is, like, we talk about their customer relationships and their supplier relationships, right? Because, again, like, the piece of information that makes the biggest difference between whether you're going to get knocked off or not is knowing that it's economically worthwhile to knock you off, right? So who are you teaching about your economic value? Well, probably your suppliers, and possibly your customers, right? And those are all people you have contracts with. So we look at those contracts to figure out, if you're properly protected, right? And we make sure that you're not giving away information that you don't need to give away. In order to
the supplier stuff, just give us an example of that. That's in my brain of not being able to just give us an example of when you counsel the company after looking at their contracts that they're giving too much information to their suppliers or vendors.
So suppliers and vendors, they don't need to know about other suppliers and vendors usually, right? Unless there's a real reason to know, they don't need to know. And they don't need to know what you're doing to their thing necessarily in order to make it into your product, right? Like, if they're a major, not just a bit supplier, right? But if they're supplying the central, core of your thing,
the aluminum for the boat you make. Yeah, right.
Yeah, like, and if they're your secret sauce, particularly, right?
You don't want A, let them know that, and B, exactly.
Yeah,
exactly. It's gonna be like, if I don't buy your aluminum, I have no business.
The potatoes for French fries, right? Whatever it is.
Let's renegotiate the cost of that aluminum, right?
Yeah. I mean, it's and key customers also, right? Especially if you're white labeling your tech, and you're charging a lot for it. What I see a lot is, companies that they launch, they have their first big customer relationships, they're still a little wobbly on their feet, as they kind of sort through some stuff, they have some supply interruptions or something like that, and they piss their customers off, having business hiccups like happen, right? And the customer's like, why do we need to deal with these clowns? We can just knock them off, right? Because we know everything that we need to know about how to do it, because we've learned it in this relationship, right? So you've got to kind of see that coming and sort of think about, how much information are you giving to people, and what do your contracts say? You can't restrain trade generally because that's an antitrust problem, but you can assert your intellectual property rights.
Right.
And so you gotta think about them. We gotta talk about them. We gotta
Right.
figure out, whether to make you as how to avoid all the vulnerabilities that we can avoid.
Right.
And mitigate all the vulnerabilities we can mitigate. So we do that. We talk about your sort of sales ecosystem and how much you're telling people and who you have contracts with and what the contracts say, and then we talk about, if there's like copyrightable subject matter, and sometimes that doesn't feel like a big thing, but I represented a company at some point that like they were sort of a trade education company, right?
Okay.
And so they prepared people to take, professional trade tests,
Yep.
right? And so they had this library of materials in all 50 states that they developed, forever. And they hadn't registered copyrights in any of that.
Oh no.
And they didn't really recognize its value. And so, they found themselves a summer intern, and I trained her how to register copyrights that really is a form you just fill out, right? And so she registered, I don't know, 500 copyrights or something like that, for them. And they had a very successful exit. They went from being a company that didn't have any IP to being a company that had a lock on some extremely valuable IP.
This is the stuff, man. No, this is exactly right. That's the perfect example, right? Is to say is like that there are often times, guys, where you don't even know what you're sitting on, right?
Yeah.
And so having a conversation with someone like Brenna,
Yeah.
Just to open up the door to say, hey, what do I have here? And what are the things that I've been doing, especially if you've been a relatively successful business for a period of time, right? And to know that you've been making a profit and that you are doing something, there are likely things there that are actually patentable or at least trade secrets or things like that is IP that can be protected, that is then going to make you more valuable overall as a company, not just because you can use this thing in creating revenue, but because having it in itself is an asset.
Mm-hmm.
Yeah. And that's the thing that I want to just emphasize to the audience is like, these patents are, and these things that you have of value are assets that are going on your balance sheet, right? They're components of value. And if you're not using them appropriately, it's like a machine that's not running, or a plant that's idle, or a person that's not being used properly. It
turns out you have a whole factory and it's not on your balance sheet.
Right, or not producing revenue, right? If you have imagine, like, no one would let a factory sit idle, because that's something that's in the news. But a lot of these companies have these assets that are maybe being used, but they're being underutilized to such as like a criminal degree, in the sense of, if all these investors knew how much intellectual property was at these companies, there would probably be an uproar of why aren't, and I'm not going to single out companies, but pharma company X or technology company Y, why aren't you using all the stuff you've created to create more value for your shareholders?
Yeah. And the answer usually is like, nobody's really looked at it. Nobody really knows why or what. And then with the small businesses, the issue is like, it's usually some people who just kind of saw a need and they figured out a solution, and they're working away at the solution, and they're thinking about, customers and orders and things like that. Their noses are to the grindstone, and to look at the intellectual property, figure out what it is and what it's good for, you have to kind of step back a little bit,
right.
And ask yourself some really basic questions about like, what are you doing? Like, what do you got? What else could it be good for?
Wow.
When a buyer comes in and they're something more than enterprise value, right? Like they're planning on doing something bigger with your thing than what you're doing with it.
Yeah.
Right. Like you often the thing that makes that sale, right, is when you can articulate the intangible assets and how they relate to a bigger thing, and that's
such a good point.
Like that's something people have trouble doing on their own, honestly.
Yeah. Absolutely. Look, like any of this stuff. Okay. And I think it's worth repeating here, guys, that, what we're trying to do always, right, is to be able to open everybody's eyes a little bit to the stuff that they are, it's easy to miss, right?
Yeah.
It's not your fault. You're head down. You're a busy person right now, right? You are growing something. You've been, as Brenna said, your nose has been to the grindstone maybe for the last 5, 10, 15, 20 years, right? You have done, but it is absolutely worth stepping back, getting someone like Brenna to be able to just take a look at what you have and what you've been doing and the way you've been doing it, and seeing what is there well in advance of you getting to a point where you're ready to sell, right?
Yes.
Because the other thing is protecting it. The other thing is being able to grow it, right? And so one of the things you may want to do when you find out that you've got this stuff that you didn't realize you have is figure out ways to license it, to do other things with it that are going to make that value again, exponentially more than just having an IP, having this IP that an asset would have a price tag on it from some buyer. It's about what you do with that IP and how you promulgate that IP, right? Into
monetize it, frankly. Yeah.
Monetize it. That's exactly right.
Yeah. And it's what else? I mean, there are people who are ready to sell their companies because, their markets kind of hit what it is, right? Like, there are people, whose businesses are like, they've sort of exhausted their technological niche, like there's now ChatGPT, the world has moved on, right? And so the thing that they think is their competitive advantage may not really be a competitive advantage anymore, right? But they have brand equity, they have know-how, they have relationships, like they still have, like they have valuable, even protectable things, and we can talk about how to articulate that in a way that isn't aimed at the kind of, vanishing market. So especially now in this time of huge technological changes in certain industries, it's all the more important to really have a strategic, thoughtful discussion. And as far in advance as the exit as possible is for all of this stuff is better, right? Because you pull me in at in the diligence phase, right? Like I can do some trademark registrations for you and we can talk about stuff, but there isn't really an opportunity to there isn't a lot of opportunity there at that point.
And that's the point, right? Is to do this just like we talked about exit planning, right? You want to do it early and often, right? There's this notion of getting in now wherever you are in the journey right now, and getting someone like Brenna in to take a look at where you are. And again, what the thing that I've learned today, and the big thing that I'll take away, is the fact that none of us really know what we're sitting on.
Yeah.
Right. Because again, it's not our expertise. It's not where our head's at. We're concerned about, top line revenue and profitability and stuff like that. And we don't even know sometimes that we've done something that really is truly innovative. Right.
Yeah. There are tech companies that, they have patent processes, right? But like everybody brings, especially into the patent discussion, people conflate, especially technical people conflate patents with all of IP. And so they miss the trade secret thing entirely. And they don't understand the value in their brand or how to leverage the value in the brand or not screw up the value in their brand, right? And so like that IP discussion is all kind of subsumed into what do I think patents are, right? So what I encourage, innovative companies to do is to just start recognizing like problem solving. Just anytime somebody solves a problem, just note it, recognize it. It may be patentable. It may be a new way to load the dishwasher that makes the kitchen cleaner, right? But you build a culture of recognizing problem solving and recognizing contributions, and then you can kind of the patent, like a healthier, more productive patent program grows from there because you're focused on the impact, and then we kind of unpack the why after we sort of flag it for impact.
Such a great point. Brenna, thank you so much for joining us today. Where's the best place that someone can reach out to you, or how do people find you to get in touch with you?
Yeah, so my law firm is inveniolaw.com, INVENIOLAW.com. I'm on the website. I'm also on LinkedIn. And reach out. I love this stuff and I'm happy to talk about it and see what you got.
That's so awesome. Awesome. Well, Brenna Legaard, a partner at Invenio LLP. Thank you so much for being here today. It was all this discussion about important discussion about intellectual property and the ways to be able to recognize it, right? That you have it, B, understand how to actually get it protected, right? And then be able to and then know what do I do with it moving forward, right? Which is to be able to, how do I monetize it? How do I make it more valuable than it is? And all of these things are directly contributing, right, to your total exit value, right? So the other thing you don't want to do, guys, is again, wait too late, right? We don't want to be sitting there. Again, as Brenna mentioned, she could be there with you at, during due diligence, and she might be able to do a couple of things that help protect some things or in fact, things that maybe the buyer even wants to have done before they take over the company to make sure everything's buttoned up. But she's not going to help you at that point. She's not going to be able to help you do much more than that. So the idea is to understand that what IP you have, examine that, learn that there may be IP you have that you don't know you have, right? Yeah. Understand what that is, be able to actually identify it, get it protected, and then be able to figure out strategically what to do with it so that you can actually make it, worth more and make your company worth more as a result. Brenna Legaard, thank you so much for being here today. We really appreciate it. You guys, you're going to see a lot more of Brenna around, hopefully moving forward here, because this discussion is obviously an important one. These are direct contributors to total exit value. And when you go through and take a look at our framework at ExitEngine, at the new ExitEngine community, you'll find at myexitengine.com. You're going to come in contact with this stuff. This is some of the stuff that we're going to, part of our framework is to have you taking a look at your IP and then be getting some help from people like Brenna. All right. So understand that your IP is one of the biggest underlying kind of pillars of your value, and it's not just about value now and about protecting the value. It's about raising that value and being able to do something with that and creating more value from that as we move forward. Right, John, as usual, man, thank you so much for being my partner. I really appreciate it. Brenna Legaard, thank you so much. It's Invenio, INVENIOLAW.com, correct?
Yep. That's right. Thanks so much.
Invenio Law, IP, and this is the Invenio becoming one of the country's leading firms here that deal with this IP stuff. So reach out to Brenna whenever you can. You'll see her hopefully down the road. We'll be doing some work, some collabs together as well. So you'll see that coming down the pike. All right, guys. What we want you to do right now, okay, is make sure first of all you are subscribing to this podcast. Okay, it's easy to do. You can do it at podcast.myexitengine.com. You can go to Apple. You can go to Spotify, anywhere you can get podcasts. You can go to our YouTube channel, which is youtube.com/ExitEngine community. Subscribe there. Subscribe somewhere so that you get this every week, right? And it's going to be automatically downloaded right to your phone. You're going to have that. We also want to hear comments from you. You can reach out and hit me and John at any time you like. We are very open about this, right, John? You can hit us just send us an email if you like, jo@myexitengine.com or John, JOHN @myexitengine.com, and find us on LinkedIn. We're all over the place on LinkedIn. But most importantly, please right now, after you subscribe to the podcast, then we want you to go to myexitengine.com. You're going to go there. You're going to see. You're going to take it. We're going to walk you through exactly what ExitEngine is, what it can do for you, how it works, and it's the place you're going to get to meet people like Brenna, like in person, like for real, and be able to have conversations with them and ask questions, and really understand everything you need to know about how to set an exit trajectory. And how to hopefully one day exit on your own terms. Thank you so much again, everybody. John, thank you. Brenda, thank you. I'm Joe Stapleton. That's John Kniff. This is the ExitEngine Podcast. We'll talk to you next week. Thanks.